Good morning, students. This is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati, signing in for, yes, company law. So, time and again, once again, you have to know that once a company is registered with the Registrar of Companies, it acquires the status of separate legal entity. That means company is different, members are different. Once the process of registration has been done, there is a curtain between the company and the members. It is known as veil, corporate veil. What it assumes that company is different, shareholders are different. Remember, but in some situations, the court will lift the corporate veil and thinks that company and the members are one and the same, and it will order an inquiry to look into the real personalities who are behind the company, who are running the company, whether the company is a dummy company, whether the company is a fraud company, or whatever it may be. So that is known as lifting of corporate veil. In yesterday's class, we have seen that the circumstances under which the corporate veil may be lifted. It is of two types. One is under judicial interpretations and another type is express statutory provisions. Statutory provisions means statute means act. So whenever a company is not following the Companies Act, or whenever a company is violating the Companies Act, then the court will lift the corporate veil. So every company, remember, in India, it has to follow the Companies Act 2013. What are all the provisions that has been enshrined in the Companies Act? Every company must invariably follow whatever be the procedures that has been enshrined in Companies Act 2013. Every company has to follow. If the company don't follow the provisions of the Companies Act, then subsequently the courts will interfere and it will lift the corporate veil and it will order an inquiry. Why? To know the purpose for which the company was incorporated. So, under the statutory provisions, that means under the Companies Act has given certain provisions to follow by every company. Every company has to follow certain provision that has been enshrined in the Companies Act 2013. If a company don't follow those provisions, then courts will interfere. Normally, under the concept of separate legal entity, courts never interfere in the internal management of the company. But in certain circumstances, court will interfere in the internal management of the company and it is known as lifting of corporate veil. So today we are going to see under what provisions the courts will lift the corporate veil under express statutory provisions. Let's analyze one by one. So first one is reduction of membership below statutory limit. The Companies Act has prescribed certain minimum number of persons to form a private company or public company. So the company must have the minimum number of members as provided in the Companies Act. The Companies Act says in case of private company, minimum 2 members should be there, and in case of a public company, minimum 7 members should be there. So 2 members in case of a private company, 7 members in case of a public company. This is the minimum that has been prescribed under the Companies Act. Minimum, remember. So, the statutory minimum limit of members is 2 in case of a private company and 7 in case of a public company. This is the minimum numbers. Now, if at any point of time the number of members of the company is reduced below this statutory limit, that means in a private company how many minimum members should be there? 2. Now 2 members has been reduced to 1. In a public company 7. In 7, that means 2 members gone away, only 5 is there. So at any point of time, the number of members of a company is reduced below this statutory limit prescribed under the Companies Act, and the company carries on business for more than 6 months with the reduced members, then every member who is aware of this fact shall be jointly and severally liable for all the debts of the company which were contracted during that period. Members has been reduced and they are carrying the business for more than 6 months. So the personal liability of the members starts after 6 months of carrying on business with reduced members. Moreover, the liability is only for the debts contracted after these 6 months. So, in a case of a private company, minimum 2 members should be there. In case of a public company, minimum 7% should be there. Here what happened? Private company minimum 2 members has been reduced below 2, and in case of a public company members have been reduced below 7 and they are carrying on the business for more than 6 months, then members are personally liable. In this situation also, courts will lift the corporate will. Remember, whatever that has been said in the Companies Act, you have to invariably follow. If you don't follow, then courts will interfere, lift the corporate wheel. Right. Now, second one is misdescription of company's name. That means you are not properly describing the company's name in all your business communication. The name of the company should be properly described in legible character in all business communication. Moreover, the name should also indicate that acts are done on behalf of the company. If the name of the company is not properly used and there is no indication that acts are done on behalf of the company, then the persons who have actually done the act will be personally liable. So, whenever the company is dealing with outsiders in all business communication, the company should properly describe its name. Let us take one example. Mr. A was a director of a company named AB Agencies Limited. A was a director in AB Agencies Limited. Right. Now, he signed a check on behalf of the company mentioning company's name as A and B Agencies. He was a director in AB Agencies Limited. Now, he signed a check mentioning company's name as A and B Agencies. In this case, what happens? The name of the company is not properly described, and thus A will be personally liable to pay the amount of the check. Whenever a company is dealing, it has to properly describe its name. If not properly described, then the persons who have actually done the act will be personally liable. In this case, Director A was personally liable. Why? In spite of AB Agencies Limited, he mentioned the company's name as A and B Agencies. So, you have to properly describe the company's name, right? Number three is fraudulent conduct of the business. Fraudulent conduct of the business. The members of the company are also personally liable for fraudulent conduct of the company's business. You know, the company has to deal fairly. If the company has been established for doing fraud, then members are personally liable. Sometimes, in the course of winding up, it may appear that the business of the company has been carried on with the intention to defraud the creditors of the company or any other person or for fraudulent purposes. So, if you establish a company to deceive the creditors, the courts will invariably lift the corporate veil and look behind the real personalities behind the incorporation of the company. You know, number of companies are coming now. For what? For defrauding the members. So, at this situation also, the courts will interfere, order an inquiry, look behind the realities of the company. This is third aspect. Number fourth one is misstatement in the prospectus. Now we are having a separate chapter on prospectus. Prospectus means it is a circular or advertisement or notice inviting the shares or debentures from the public. So, normally, when a company wants to issue shares, debentures, it has to issue prospectus. For example, if you want to join in a college, college will give you the prospectus. What prospectus contains? It contains details of the college, who is the chairman, who is the president, who are the promoters. Likewise, there is a detailed description about the college when it has been established, so on and so forth. Likewise, when a company wants to issue shares, it has to issue prospectus. The prospectus should contain the name of the company, who are the promoters, who are the directors, who are behind the company, and how they are going to invest your money in different projects. Everything is presented in the prospectus. Once if you issue the prospectus, subsequently you cannot deviate from the prospectus. So, a prospectus is a document issued by the company inviting offers from the public for what? For the purchase of its shares or debentures or to invest money with the company. So, the prospectus must therefore represent to the public the true facts relating to the affairs of the company. Remember, the prospectus should contain always true facts. If the prospectus contains any misstatement, that means untrue statement, right? Then every director of the company, every promoter of the company, and every person who authorized the issue of the prospectus shall be liable to pay compensation to the subscriber for any loss sustained by him by reason of any untrue statement contained in the prospectus. Thus, the directors, promoters, etc., incur personal liability for the issue of a false prospectus. Moreover, they are also liable for damages for deceit under the law of torts. So whenever you are issuing the prospectus, you have to tell true statements about the company. If you tell untrue statements, then every director and promoters are personally held liable. Fourth one, we have seen misstatement in the prospectus. Number fifth is directors with unlimited liability. Now, the liability of the directors of a limited company is limited, like other members of the company. However, the memorandum of the company may contain a provision that the liability of the director shall be unlimited. It may be noted that either the memorandum may originally contain such provision or it may be subsequently altered by passing a special resolution so as to make the director's liability unlimited. In case of unlimited liability of the directors, they shall be personally liable for the debts of the company. So you know that limited liability, unlimited liability. Liability means what? You have to pay the amount. Limited liability means if a company issue shares and one share is rupees 10, if you purchase one share, your liability is only rupees 10 only. If the company asks you to pay even more than 10 rupees, you say my liability is limited to 10 rupees only. That is limited liability. Unlimited liability means the company will ask you, the company is going in winding up process, please give some extra money. Whatever be the money you are having, the company will lose. That means this will extend even to your personal property. So now directors with unlimited liability, they shall be personally liable for the debts of the company. Number sixth is liability for pre-incorporation contracts. Pre-incorporation. Pre means before. Before the company has come into existence, what happens? Promoter will enter into so many contracts. You know that company will come into existence only on registration with register of companies and only a certificate of incorporation is given. Then only company comes into existence in the eyes of the law. Now, company does not come into existence now. For the company to come into existence, you are entering into so many contracts, and these are known as pre-incorporation contracts. A pre-incorporation contract is one which is entered into, that is made by the promoters even before the formation of the company. So after the formation of the company has to adopt or accept the pre-incorporation contract. Company will tell to promoters, you don't worry, I am taking all your contracts now. If the company don't accept those pre-incorporation contracts, then promoters are personally liable for all such contracts which are not adopted by the company after its formation. Right? Number seventh one is Ultraviolets Act. Ultraviolets means beyond the powers. Now, the directors get the powers. You know, company is run by the directors. From where directors are getting the power? From Companies Act, from Memorandum of Association, and from Articles of Association, and from the resolutions passed by the shareholders. These are the four ways in which the directors derive their power. Now, the Ultraviolets Acts are those which are not the authorized act, not authorized by Companies Act, not authorized by Memorandum of Association, not authorized by Articles of Association, and not authorized by a special resolution. So in this case, the directors of the company are personally liable for all the Ultraviolets Acts, even if they are done on behalf of the company. There is a separate concept is there. When that concept comes, we will discuss in detail. The Ultraviolets Acts may be categorized in two types. Acts ultraviolets the company, acts ultraviolets the company, acts ultraviolets the directors. So directors are also personally liable for the acts which are in the nature of tort. Yeah. So we have discussed about holding and subsidiary companies. Once again, let us recapitulate. A holding company is one which has control over another company. For example, a company is there, right? A is making good profits, huge profits. Now, A wants to establish another company. So, A is the main company. A wants to establish another company, and B company has come into existence. A is the main company and B is a sister concern. Here what happens? A is getting more profits. It is establishing another company by name B. So here A is establishing B company means A is holding company and B is a subsidiary company. So who will appoint directors in the B company? A will appoint. Then who will hold shares, majority of shares in the B company? A will hold majority of shares. That means a company which holds majority of shares, which controls the board of directors, it is known as a holding company, and B is known as a subsidiary company. Now B is also getting more profits. B establishes another company by name C. Now C is subsidiary of B company, B is subsidiary of A company, then B and C subsidiaries of A company, that is known as subsidiary of another subsidiary company. A is a holding company, B is subsidiary company. B is holding company, C is subsidiary company. B and C are subsidiaries of A, that is holding company. So these are the three ways in which you can define the holding and subsidiary companies. Number first point is control over the composition of board of directors. Next, holding of majority of shares. Number 3 is subsidiary of another subsidiary company. Yes, students, I think you got something today. It's Sreekanth signing off today. Have a good day, children.